Usually, when we talk about a medical diagnosis, there is this expectation of, like, mechanical precision.
Right, yeah, absolute certainty.
Exactly. Like break your arm, you go to the hospital, and the X-ray produces this stark black and white image.
Mm-hmm.
The jagged white line of the fracture is just, it's right there. The doctor points to it, and it's a binary reality.
It's broken or it's not.
Right. It's clean, it's visible, and honestly, it's comforting.
Oh, we definitely crave that kind of empirical categorization, especially when the stakes are really high.
But if you step into the American pretrial criminal justice system, that X-ray machine just shatters completely.
Oh, it's the absolute antithesis of a clean X-ray.
Right. We are suddenly operating in this diagnostic landscape that is entirely murky. I mean, instead of reading a physical bone fracture, we're trying to read the decaying half-life of human memory.
Yeah, which is terrifying.
It is. We're trying to measure intent. We're trying to pinpoint the exact millisecond a constitutional right activates, as a clock is literally ticking down in a holding cell.
Pretrial criminal procedure is just this intricate, highly subjective machine. It's built largely on, well, the shifting sands of human perception and, frankly, institutional power dynamics.
And look, if you are staring down the barrel of the multi-state bar examination right now, this deep dive is specifically for you.
Yeah, we know exactly how intimidating this material feels.
It's a lot. It looks like this giant labyrinth of ancient rules followed by exceptions and then, exceptions to those exceptions.
Right, and the trap that most law students fall into is trying to rote memorize it all, like a phone book.
Which is impossible.
Completely. And it doesn't work under the pressure of the MBE. To actually survive the exam, you have to understand the underlying architecture of the system.
The why.
Exactly. You have to understand why the rules evolved the way they did and how they function mechanically to balance, state power against individual liberty.
So our mission today is to map that architecture. We are going to strip away the impenetrable academic jargon and examine the actual mechanisms of the law. We'll use clear, explanatory English. We'll stress test the rules with some hypotheticals, and we're going to constantly anchor our discussion with MBE recaps.
Just to ensure the really high-yield, need-to-know rules actually stick in your memory.
Right. Because we're going to trace the chronological timeline of a criminal case, starting from the exact moment a suspect is identified out in the world.
The very beginning.
Yep. Tracing their path through detention, the mental competency checks, the really secretive charging phase, all the way to the prosecutor's desk right before the trial gavel falls.
It is a total gauntlet. And I mean, the very first hurdle in that gauntlet is how the state secures its target in the first place.
Before a trial can even begin.
Right. Before we can even debate bail conditions or grand jury indictments, law enforcement needs a witness to look at a human being and say, that is the person who did it.
Okay, so we start in what I call the lineup lab.
I like that.
And logically, this is where the system is perhaps at its most fragile, right? Because eyewitness identification is just notoriously unreliable.
Oh, entirely.
But before we get into the psychology of memory, let's categorize the tools the police actually use. So the source material divides identification procedures into two primary buckets. Corporeal and non-corporeal.
Yeah, and the distinction there is purely physical. So corporeal literally means of the body.
Okay.
These are the classic in-person procedures. So if you picture like a standard police procedural on television, you're picturing a corporeal lineup.
The classic lineup.
Exactly. 5 or 6 individuals standing in a brightly lit room behind a two-way mirror while a witness looks on.
Right.
Or another corporeal method is the show-up.
Oh, what's that?
That's where police bring a single, physical suspect directly to the witness. It's usually out in the field, like shortly after the crime occurred.
Got it. And then non-corporeal just simply removes the physical body from the equation altogether.
Exactly. Non-corporeal procedures almost entirely involve photographs.
Like a mugshot book.
Yeah, the police hand a witness a folder, or maybe they show them a screen containing an array of 6 different mugshots and they ask if the perpetrator is among them. The suspect themselves is nowhere in the building.
Okay, so this physical distinction seems simple enough. But mechanically, for the bar exam, the type of identification procedure combined with exactly when it happens on our chronological timeline.
This is the crucial part.
Right. It determines whether the defendant gets to invoke one of the most powerful shields in the Constitution, the Sixth Amendment right to counsel.
Oh, yeah. This is a really heavily tested intersection. The Sixth Amendment guarantees a defendant the right to have a lawyer present at critical stages of the criminal prosecution.
But it's not always on.
No, that right is definitely not omnipresent. It is a very specific activation condition.
I try to visualize the Sixth Amendment right to counsel in this context as like an exclusive heavy-duty blast shield.
Okay, I can see that.
You can carry the button for it in your pocket, but the circuitry only connects. The shield only deploys after a very specific institutional trigger is pulled.
That is a great way to think about it. And that trigger is the initiation of formal adversarial proceedings.
Which means what, exactly?
Usually that means an indictment or a formal charging instrument. The Supreme Court has established that a defendant has an absolute right to have their counsel present at any post-indictment in-person lineup or show up.
Post-indictment. Okay, why that specific trigger? Like, why does the indictment activate the shield?
Because the indictment represents a fundamental shift in the machinery of the state.
How so?
Well, before the indictment, the police are merely investigating a crime. They are just gathering facts out in the world.
Right.
But once an indictment drops, the government has officially committed itself to prosecuting that specific individual. The relationship is now purely adversarial.
Ah, I see.
So at that point, a corporeal lineup isn't just an investigation anymore. It's a critical, staged event orchestrated by the prosecution to build their trial case.
And the lawyer needs to be in the room because an in-person lineup is incredibly dynamic, right? It's literally a live theatrical performance.
Precisely.
If the lawyer isn't there, they can't recreate it later.
Exactly. If a witness hesitates for like 5 whole minutes, or if the police officer subtly clears their throat when the witness looks at suspect number 3.
Oh, right, the little fuse.
Yeah, the official police report will never reflect that. The report will just say, witness positively identified the defendant.
Case closed.
Right. So the defense attorney needs to be standing in that viewing room to observe the staging, the lighting, all those subtle cues, so they can actually cross-examine the witness effectively later at trial.
That makes total sense. If the lawyer isn't there, the data of that fleeting moment is just lost forever.
Gone.
Okay, let me stress test the boundary of this rule because it feels like there's a massive loophole here.
All right, lay it on me.
Let's say I'm walking out of a grocery store. The police tackle me, arrest me for an armed robbery that happened down the street, and they throw me in the back of a squad car.
Okay.
I am handcuffed.
Yeah.
I'm definitively under arrest. My liberty is gone. They drive me straight to the station and immediately put me in a physical lineup behind the glass. I haven't been formally indicted yet because, well, the arrest happened 10 minutes ago. Can they run that corporeal lineup without my lawyer?
They absolutely can.
Wait.
Yes, and this is perhaps the most common MBE trap in this entire section. The Supreme Court has ruled that the Sixth Amendment right to counsel does not apply to any pre-indictment lineup, period.
That seems functionally bizarre. I mean, from the perspective of the suspect, what is the difference? I am locked in a police station being paraded in front of a victim. The adversarial weight feels pretty heavy to me.
I know, it feels heavy. But legally, the Supreme Court drew a hard line in the sand. They reasoned that an arrest is just the culmination of police investigation, not the start of the judicial prosecution. The constitutional right to counsel is considered a trial right.
So it only goes backwards so far.
Exactly. It stretches backward only as far as the formal charging document. If they haven't indicted you, your blast shield has no power.
That is wild. Okay, what if I am already under arrest for something else?
Okay.
Say I am sitting in jail awaiting trial for a completely unrelated tax fraud charge. So I've been indicted for the tax fraud.
Caught it.
But the police suspect me of a recent string of burglaries. Can they pull me out of my cell and put me in a physical lineup for the burglaries without my lawyer?
Yes, they can.
Because it's a different crime.
Exactly. The right to counsel is offense-specific. Your blast shield is only activated for the tax fraud charge. Because you have not been formally charged with the burglaries, you have no Sixth Amendment right to a lawyer at that specific burglary lineup.
Wow. Okay, so pre-indictment physical lineup, no lawyer required. Post-indictment physical lineup. Lawyer is mandatory. What about the non-corporeal procedures? The photo arrays?
For non-corporeal procedures, the Sixth Amendment right to counsel never applies.
Never. Even if I have been indicted, arraigned, and my trial starts tomorrow morning?
Never.
If the police show a witness a photo array today, my lawyer doesn't get to be there.
They do not. The Supreme Court established that there is no right to counsel at a photographic display, regardless of when it occurs on the timeline.
But why?
The mechanical reasoning here goes back to what we discussed about the dynamic nature of physical lineups.
Right, the theatrical performance.
Yeah. A physical lineup is a fleeting event. A photo array, on the other hand, is static. It's just a piece of cardboard or a digital file.
Oh, I see.
So the police can simply hand that exact same array to the defense attorney during discovery months later.
And the attorney can just look at it.
Exactly. The defense attorney can look at the photos, see if the defendant's picture was unfairly prominent, and cross-examine the witness about it at trial. Because the procedure is perfectly reproducible, the lawyer's physical presence during the actual viewing isn't constitutionally required to preserve a fair trial.
That logic actually holds up.
Yeah.
So what is the mechanical penalty when the police actually do violate the rule?
Okay.
Let's say we are post-indictment, the blast shield is fully active, but the police run a corporeal lineup anyway, and they just don't invite my lawyer. Does my whole case get dismissed?
No, it does not result in an automatic dismissal of the charges. But it does trigger a severe evidentiary penalty.
Which is?
It's known as a per se exclusionary rule. The prosecution is absolutely prohibited from introducing any evidence of that out-of-court identification at the trial.
So they can't even mention it.
Right. They cannot put the witness on the stand and ask, did you pick the defendant out of a lineup at the police station? That specific piece of evidence is dead.
But the prosecutor's real goal isn't usually just talking about the police station, right? The goal is having a witness point dramatically across the courtroom at the defense table and say, that is the person.
The classic TV moment.
Exactly. So if the police botch the station lineup, is the witness still allowed to make an in-court identification?
That is the crucial secondary layer of this doctrine. The witness might still be allowed to identify you in court, but the prosecution has to climb a very steep evidentiary hill.
What do they have to do?
They must prove to the judge by clear and convincing evidence that the in-court identification has an independent source.
Independent of the illegal lineup, you mean?
Yes. The prosecution has to show that the witness's memory of the defendant comes from the actual commission of the crime itself, not from the suggestive, lawyerless lineup they saw at the station.
How does a prosecutor prove the origin of a memory in someone's brain? That sounds impossible.
It's tough. They look at the environmental factors of the crime itself. Did the witness have a clear view of the attacker's face in broad daylight for 10 straight minutes? Or was it a fleeting glance in a dark alley?
Oh, okay.
If it was broad daylight, the judge might say, well, the witness clearly remembers the face from the attack, so they can point to the defendant in court, despite the botched lineup.
Makes sense.
But if it was a fleeting glance in the dark, the judge will likely conclude the witness only recognizes the defendant because they saw them under bright lights at the police station.
Right. The memory was tainted.
Exactly. In that case, the in-court identification is banned as well, and the prosecution's case often collapses.
Okay. That covers the Sixth Amendment approach, the timeline trigger.
Yeah.
But our sources detail a completely different parallel avenue for attacking an eyewitness identification.
Yes, they do.
And this one doesn't care about the timeline at all. It's grounded in the Due Process Clause of the Fifth and 14th Amendments.
Right. If the Sixth Amendment is about who gets to be in the room, namely, your lawyer, the Due Process Clause, is entirely concerned with how the procedure was conducted.
The fairness of it.
Precisely. It asks whether the identification procedure was so fundamentally unfair that it violates the basic tenets of justice. The legal standard is whether the procedure was impermissibly suggestive.
And mechanically, this protection is active at all times.
Yes, always. Pre-indictment, post-indictment, corporeal, non-corporeal. It applies universally. If the police arrange an identification process that essentially neon signs the suspect to the witness, it violates due process.
Let's define the standard. If I am the defense attorney and I want to suppress a witness's identification based on due process, what exactly do I have to prove to the judge?
You have to satisfy a pretty stringent two-prong test. Prong 1. You must prove that the police procedure was impermissibly suggestive.
Okay.
But that isn't enough on its own. Prong 2 requires you to prove that the suggestiveness was so severe that it created a substantial likelihood of misidentification.
That second prong makes sense because I imagine there are scenarios where a lineup is a bit suggestive, but the witness is incredibly confident for other reasons.
Exactly. The courts recognize that not all suggestiveness fatally corrupts the memory. To evaluate that second prong, the likelihood of misidentification courts use a specific framework of reliability factors. These factors are designed to measure the underlying reliability of the witness's memory, completely apart from whatever suggestive nonsense the police did.
We need to unpack these reliability factors thoroughly, because I can easily see an MVE question presenting a fact pattern and asking us to weigh them.
Oh, absolutely.
So how does the court actually measure reliability?
There are 5 core factors you need to know. First is the witness's opportunity to view the criminal at the time of the crime.
So spatial and environmental.
Right. Were they 2 feet away or 50 yards away? Was it noon or midnight? Were there street lights?
Just the raw physical capacity of the human eye to capture the data.
Exactly. The second factor is the witness's degree attention. This is where we get into the psychology of trauma. Was the witness a casual observer walking their dog across the street? Or were they the direct victim of an armed robbery?
You would think a victim has a much higher degree of attention,
Yeah.
but psychology tells us about the weapon focus effect, right?
Oh, yeah.
Like if someone shoves a revolver in my face, I am staring down the barrel of that gun, not studying the curvature of their jawline.
Exactly. And defense attorneys use that exact psychological argument to attack the degree of attention.
Interesting.
The third factor is the accuracy of the witness's prior description of the criminal.
Meaning what they told the cops before the lineup.
Yes. If, 5 minutes after the mugging, the witness told police the attacker was a 6-foot-tall blonde man with a facial tattoo, and the defendant happens to be a 6-foot-tall blonde man with a facial tattoo, that prior accuracy weighs heavily toward reliability, even if the subsequent lineup was suggestive.
But if they described a short brunette and then point to the tall blonde in the lineup, reliability plummets.
Precisely. The fourth factor is the level of certainty demonstrated by the witness at the confrontation.
Okay.
When they looked at the lineup, did they say, "I'm 100% positive, I'll never forget those eyes," or did they hesitate and say, number 3 looks the most like him, I guess?
Although, again, psychological studies show that witness certainty is actually a terrible predictor of accuracy. Witnesses often become more certain specifically because of the suggestive police procedure.
The scientific community widely agrees with you on that. But the Supreme Court still firmly embeds witness certainty as a legal factor in this test. You have to apply the law as it is written for the exam.
Fair enough. What's the last factor?
Finally, the fifth factor is the length of time between the crime and the confrontation. Did the police run the show up 20 minutes after the robbery, or did they show a photo array 2 whole years later?
Right. The half-life of human memory is brutally short.
Very much so.
So the judge takes all 5 of these factors, puts them on one side of a scale, and puts the corrupting effect of the police suggestiveness on the other. If the reliability outweighs the suggestiveness, the jury gets to hear the ID.
That is the exact mechanical balancing test, but there is a massive constitutional caveat to all of this, highlighted in a relatively recent Supreme Court case.
Well,
Due process only protects you from suggestiveness created by law enforcement.
created by them. Let me test that. What if the suggestiveness is just like a cosmic accident?
Then the Constitution doesn't care.
Seriously.
Yeah. In this specific case, the police responded to a car break-in at an apartment complex. One officer was downstairs in the parking lot, standing next to the suspect. Another officer was upstairs in the victim's apartment, asking her to describe the thief.
Okay, setting the scene.
The victim organically walked over to her kitchen window, looked down into the dark parking lot, saw the suspect standing right next to a uniformed police officer, and said, "That's the guy."
Wow. Looking through a window into the dark and seeing the only civilian standing next to a cop is wildly suggestive. It inherently implies, hey, we caught the bad guy.
It is deeply suggestive, but the Supreme Court ruled there was zero due process violation because the police didn't arrange the staging.
Because she just walked to the window on her own.
Right. The officer upstairs didn't tell her to look out the window. The officer downstairs didn't purposely pose the suspect under a spotlight for her benefit. It was just a spontaneous consequence of the environment.
That's fascinating.
The court held that the due process clause is meant to deter police misconduct. If there is no police orchestration, there is no constitutional violation. The ID comes in, and it's up to the defense attorney to argue to the jury that the window viewing was unreliable.
That is a brilliant nuance to remember. Who arranged it is the threshold question. Now, what about situations where the police absolutely do arrange something highly suggestive, but they are forced to by circumstance? Like, they just don't have time to construct a fair 5-person lineup.
You are referring to the necessity exception. This is best illustrated by a really visceral, famous case involving a hospital bed.
Oh, tell me.
In this scenario, a victim was brutally stabbed and was fighting for her life in a hospital bed. She was scheduled for major surgery, and her doctors could not guarantee she would survive the night.
The ultimate ticking clock.
Yes. The police had apprehended a suspect. They needed to know if they had the right person before the only eyewitness in the world potentially died. So they brought the suspect directly into the victim's hospital room.
Oh, God.
He was handcuffed to a police officer, surrounded by several other uniformed cops, and the police explicitly asked the victim, "Is this the man?"
Mechanically, that is the most suggestive procedure imaginable, short of handing the witness a script.
Mhm.
I mean, you are presenting a caged human being surrounded by authority figures.
It is the literal definition of impermissibly suggestive. However, the Supreme Court ruled that under the totality of the circumstances, it was not a due process violation
Because of the ticking clock.
because it was strictly necessary. The police could not wait days to build a fair lineup. The witness might be dead. They could not move the witness to the station. The exigency of the medical emergency completely justified the suggestive nature of the one-on-one show-up.
So if the MBE gives you a scenario with a dying witness or an active ticking bomb emergency, the necessity might excuse the suggestive police procedure.
Exactly.
Okay, we have navigated the lineup lab. Let's lock in our first MBE recap segment. What are the high-yield rules for eyewitness identifications?
Rule number 1. The Sixth Amendment right to counsel is a blast shield that only activates post-indictment. It guarantees your lawyer's presence at any in-person corporeal lineup or show-up.
But not before.
Right, it does not apply pre-indictment, and it never applies to non-corporeal photo arrays.
Rule number 2. The due process protection against impermissibly suggestive identification procedures applies universally at all times on the timeline. But to suppress the ID, the defense must prove a two-pronged test: that the police arranged the suggestiveness and that it created a substantial likelihood of misidentification under the 5 reliability factors.
Rule number 3, the exceptions. If the suggestive scenario was accidental and not arranged by police, or if it was justified by a severe emergency necessity, it will survive a due process challenge.
Excellent. Okay, so we've got our suspect identified. We move forward on our chronological timeline to Section 2. The police slap the cuffs on, and the suspect is arrested.
The dynamic fundamentally shifts here.
Right, because the state has physically seized a person's liberty. But they cannot just throw someone in a lightless hole and throw away the key. The Constitution sets a ticking clock.
It does. The moment of arrest triggers the Fourth Amendment's protection against unreasonable seizures. When police arrest someone out in the field without a pre-existing warrant, say, based on a witness pointing them out in the lineup lab, the state has unilaterally decided to take their freedom.
Right.
The system demands that a neutral judge quickly verify that the police actually have probable cause to justify that continuing detention.
This verification mechanism is usually called the probable cause hearing to detain.
Exactly. It is a judicial determination of probable cause, and it is crucial to understand what this hearing is not. It is not a trial. It is not an assessment of whether the state can prove the defendant guilty beyond a reasonable doubt.
Let me try a mechanical analogy here.
Let's hear it.
When you check into a hotel, they ask for your credit card. They don't actually process the final payment for the entire week-long stay then.
No, they don't.
They just run a hold on your card for a few $100s. They just need enough preliminary proof right in that moment that you are good for it, that there is a valid justification to freeze a portion of your funds.
That is the perfect mechanism. This hearing is the judge verifying the hold on your liberty. The police just need to show enough preliminary evidence, probable cause, that you committed a crime to justify keeping you in a jail cell while they build their full case.
Now, you mentioned a ticking clock. How long can the police keep you in the holding cell before they have to run this credit check with the judge?
The Supreme Court set a very specific presumptive time limit here. The hearing must be held within 48 hours of a warrantless arrest.
48 hours. What if I am arrested at 10 p.m. on the Friday of a 3-day holiday weekend? Does the clock pause for the weekend?
It does not pause.
Wow.
The court explicitly balanced the administrative burdens of the police against the severe deprivation of human liberty. They concluded that 48 hours is the absolute outer limit for a systemic delay, regardless of weekends or holidays.
So the police just have to figure it out.
Basically, if the state holds you for 60 hours without seeing a judge, the burden shifts entirely to the government to prove there was a bona fide emergency that prevented the hearing.
Let's step into the courtroom for the hearing itself. What does it look like? Do I get to stand up and argue? Does my lawyer get to cross-examine the arresting officer?
No, and this is a vital distinction for the MBE. This probable cause to detain hearing is entirely non-adversarial. You do not have a constitutional right to have your defense counsel present. There is no cross-examination. In many jurisdictions, the defendant isn't even in the room. The prosecutor simply hands the judge a piece of paper, a sworn affidavit from the arresting officer detailing what happened.
Wait, just an affidavit. What about the rules against hearsay?
Hearsay is perfectly admissible in this hearing. The officer's affidavit might say, "The victim told me the defendant stole the purse." That is textbook hearsay. But the judge can accept it, look at the paper, and say, "Yep, that establishes probable cause, keep him detained."
So the state holds all the cards in this hearing. Let me test the enforcement of that 48-hour clock, because this is where students get tripped up.
Before it.
Let's say the police totally blow the deadline. They arrest me on Friday night and just leave me rotting in a holding cell until Tuesday morning, 80 hours later. The 48-hour rule is completely shattered. Does the judge look at the clock, declare a constitutional violation, and dismiss the robbery charges against me?
Absolutely not. This is a classic trap. The failure to hold a timely hearing does not result in a dismissal of the underlying criminal charges. You do not get a get-out-of-jail-free card just because the police were slow with paperwork.
If the charges aren't dropped, what is the actual penalty for the state? Like, what stops the police from just ignoring the 48-hour rule altogether?
The penalty is evidentiary. If the police hold you unlawfully past the 48-hour mark, any evidence they acquire as a direct result of that unlawful delay will be suppressed at trial.
Give me an example.
For example, if you are sitting in that cell in hour 70, you haven't seen a judge, and out of sheer exhaustion and despair, you confess to the robbery, that confession is almost certainly getting thrown out as the fruit of the illegal detention. But the robbery charge itself remains active.
Okay, the evidentiary penalty makes sense. Now, this probable cause hearing is just one of several preliminary proceedings mentioned in our outline. And honestly, they all sound remarkably similar. We have the initial appearance, the arraignment, and the preliminary hearing. Mechanically, how do we keep these straight?
You have to look at the specific function of each hearing. The initial appearance usually happens very quickly after arrest. It is largely administrative.
Like reading rights.
Exactly. The judge formally advises the defendant of the charges against them and informs them of their constitutional rights. If the defendant is indigent, this is the moment the judge will typically appoint a public defender.
And practically, in many busy courthouses, the judge handles the probable cause check and the initial appearance at the exact same time, right?
Yes. They often consolidate the paperwork to save time. Next is the arraignment. The specific mechanical function of an arraignment is to elicit the defendant's formal plea to the charges.
Okay.
The judge reads the indictment and asks, "How do you plead?"
And the defendant says, "Not guilty, Your Honor."
Exactly. The arraignment locks in the battle lines. But the most important distinction you need to make for the exam is between the probable cause hearing to detain and what is called the preliminary hearing.
Wait, we just did a hearing to determine probable cause. Where are we doing another one?
Because the first hearing only determined probable cause to detain, meaning, is there enough evidence to keep you locked up today?
Right.
The preliminary hearing serves a much heavier function. It determines whether there is sufficient probable cause to prosecute, meaning, is there enough evidence to drag you through the massive ordeal of a full-blown trial?
So the standard is the same probable cause, but the stakes are much higher. How does that change the mechanics of the hearing?
It changes everything. Because the stakes are higher, the preliminary hearing is a fully adversarial proceeding. It is a mini-trial.
So my blast shield is active.
Yes. And because it is adversarial, the Supreme Court ruled that the preliminary hearing is a critical stage of the prosecution. Therefore, the defendant has an absolute Sixth Amendment right to have their counsel present, to cross-examine the state's witnesses, and to challenge the evidence.
Let me make sure I have this distinction locked in. Probable cause to detain hearing happens within 48 hours. Non-adversarial, hearsay allowed, no right to a lawyer. Preliminary hearing, determining probable cause to prosecute, fully adversarial, absolute right to a lawyer.
Burn that exact dichotomy into your brain for the MBE. One vital caveat, though.
What is it?
If the prosecutor has already gone to a grand jury and secured a formal indictment, the preliminary hearing is bypassed entirely.
Why?
Because the grand jury has already determined there is probable cause to prosecute, so the adversary hearing becomes moot.
That brings us to the elephant in the room regarding detention. The system has decided there is a probable cause to hold me, but I haven't been convicted of anything yet. I am presumed innocent, so I want to get out. I want bail.
Natural.
And I think popular culture has deeply warped the public understanding of this. Doesn't the U.S. Constitution guarantee every citizen the right to get out on bail?
It does not. This is one of the most pervasive myths in constitutional law. There is no explicit constitutional right to be released on bail.
I feel like people quote the Eighth Amendment all the time regarding bail.
They do, but they misread it. The Eighth Amendment simply states, excessive bail shall not be required.
Okay.
Mechanically, it does not say the state must offer you bail. It just says that if the state chooses to set a dollar amount for your release, that specific number cannot be unconstitutionally excessive.
So, a judge can look at me and say, you are a danger to the community, I am denying bail entirely, you are staying in a cell until trial, and that does not violate the Constitution.
That is perfectly constitutional, provided the denial comports with basic procedural due process, meaning the judge has to hold a hearing and state their reasons on the record. Preventive detention is legal. The Eighth Amendment protection only kicks in when the judge actually names a price.
How do we define excessive then? Let's say I am charged with stealing a $500 bicycle. The judge sets my bail at $10 million. I obviously can't pay it. Is that excessive?
Yes, very. The Supreme Court has defined excessive mechanically. Bail is excessive if it is set at a figure higher than an amount reasonably calculated to fulfill its primary purpose.
And what is the primary purpose?
It is not to punish you. It is simply to ensure that you actually show up for your trial. A $10 million bail for a stolen bicycle is completely disconnected from the risk of flight. It is effectively a denial of bail disguised as a number, and that violates the Eighth Amendment.
If a judge sets an excessive number or denies bail outright, what can the defense do?
Those decisions are subject to immediate interlocutory appeal. You don't have to wait until after the trial to appeal your bail conditions.
In reality, how are judges making these decisions? Because they can't just throw darts at a board.
The modern bail system is heavily governed by statute, which many states have mirrored off the federal rules. The key mechanism to understand in these statutes is the shifting of presumptions based on the timeline.
Explain the presumptions.
When you first go before a judge pretrial, you are draped in the presumption of innocence. Therefore, the statute creates a strong presumption in favor of pretrial release.
So the default is, I get out.
The baseline default is that you should be let go, either on your own recognizance or with reasonable conditions. The burden is on the prosecutor to overcome that presumption by proving you are a severe flight risk or a danger to the community.
But the timeline shifts that presumption later on.
Radically. Let's fast forward. You go to trial, you lose, you are convicted, and the judge sentences you to 10 years. Your lawyer files an appeal.
Okay.
While the appeal works its way through the appellate courts over the next 2 years, you ask to be out on bail. At this post-conviction stage, the presumption flips entirely. There is a strong presumption against bail pending appeal.
Because you aren't innocent anymore.
Exactly. You are legally guilty. The burden is now on you to prove that you are not a flight risk, not a danger, and that your appeal raises a substantial legal question likely to result in a reversal.
That makes logical sense. Let's address the grim reality of the people who don't get bail. The people who are detained pre-trial, again, they are legally presumed innocent. Does that presumption protect them from the harsh conditions of a jail environment? Can they be treated like hardened convicts serving a sentence?
The Supreme Court has been surprisingly deferential to jail administrators on this issue. While pretrial detainees cannot be subjected to conditions that amount to explicit punishment prior to an adjudication of guilt, their constitutional rights are severely curtailed by the overriding administrative need for institutional security.
Institutional security sounds like a blanket excuse to do whatever they want.
It acts like one. The Supreme Court has upheld a wide range of highly intrusive practices for pretrial detainees, so long as those practices are reasonably related to maintaining jail security.
Like what?
For instance, the jail can prohibit you from receiving outside food or personal belongings. They can conduct unannounced, routine inspections of your cell without probable cause. They can force you into double bunking in a cell designed for one person to manage overcrowding.
What about physical autonomy? Body searches?
Even there, the security rationale triumphs. The Supreme Court has upheld policies requiring pretrial detainees to undergo visual body cavity searches after contact visits with the outside world.
Even if there's no suspicion.
Even if the guards have zero reasonable suspicion that the specific detainee is hiding contraband. The baseline rationale is that jails are inherently dangerous places, and the administrators must be given wide latitude to keep weapons and drugs out, regardless of the detainee's presumed innocence.
It is a stark reminder of the physical weight of the system. Let's do our MBE recap for Section 2, the ticking clock of preliminary proceedings.
First, the warrantless arrest rule. A warrantless arrest requires a judicial determination of probable cause to detain within 48 hours. This hearing is non-adversarial hearsay, is admissible, and there is no constitutional right to counsel. Missing the deadline does not dismiss the charges, but it does suppress evidence acquired due to the delay.
Second, the preliminary hearing rule. This hearing determines probable cause to prosecute. It is a critical adversarial stage. The defendant has an absolute right to counsel.
Third, the bail rules. There is no constitutional right to be released on bail. The Eighth Amendment only dictates that if bail is set, it cannot be excessive, meaning higher than necessary to ensure appearance at trial. And remember the statutory presumptions. The system presumes in favor of release pretrial, but heavily presumes against release post-conviction pending appeal.
Spot on. We are moving to Section 3. Up to this point, our chronological timeline has assumed that the person sitting in the cell, standing in the lineup, and listening to the bail hearing actually understands the words being spoken around them.
A huge assumption.
Right. But the American justice system cannot function if the mind of the defendant is broken.
No, it can't. The integrity of the entire adversarial process relies on the defendant's ability to participate. If the state is going to bring the full weight of its prosecuting power down on an individual, due process demands that the individual must be mentally present. This is the doctrine of competency.
And the rule is absolute, correct?
It is an absolute constitutional bar. You cannot, under any circumstances, try, convict, or sentence an incompetent person.
Period.
Period. If at any point during the proceedings evidence emerges that raises a bona fide doubt about the defendant's competency, the trial judge has an affirmative constitutional duty to immediately halt the proceedings and order an evaluation. Failing to do so is a structural violation of the defendant's right to a fair trial.
But how does the law actually define a broken mind? We need a mechanical test.
The Supreme Court established a two-pronged test focused entirely on the defendant's present ability to function in the legal environment. First, does the defendant have a rational as well as factual understanding of the proceedings against them?
Meaning, do they know the difference between the judge and the prosecutor? Do they understand what the charges mean and what the potential punishment is?
Exactly. They don't need a law degree, obviously, but they need baseline comprehension. The second prong is functional. Does the defendant have sufficient present ability to consult with their lawyer with a reasonable degree of rational understanding?
Meaning, can they actually assist in their own defense? Can they tell their lawyer where they were on the night of the crime or point out if a witness is lying?
Right. If a defendant believes their lawyer is a demon sent from Mars and refuses to speak to them, they fail the second prong, even if they intellectually understand what a trial is.
Let's follow the timeline. The judge stops the trial. They hold a hearing, the psychiatric experts testify, and the judge concludes the defendant fails the competency test. They are legally incompetent. What is the immediate mechanical result? Do the charges get dropped and the person goes free?
No. The criminal proceedings are suspended, and the defendant is typically committed to a psychiatric facility for treatment. The goal of this commitment is strictly limited. The state is trying to restore the defendant to competency so the trial can resume.
And this brings us to one of the most intense, controversial, and highly testable areas of pretrial law: forced medication.
It's a huge issue.
If a defendant is locked in a psychiatric ward, completely divorced from reality, can the government physically force them to take antipsychotic drugs against their will, solely to make them lucid enough to stand trial?
It sounds dystopian, but the answer is yes, under specific parameters set by the Supreme Court. However, because forcibly medicating someone is such a massive infringement on their constitutional right to bodily autonomy, the court built an incredibly steep hurdle for the government to clear.
Walk me through this hurdle. How does the government justify putting a needle in someone's arm?
First, the government must prove that important governmental interests are at stake. This usually means the defendant is facing serious criminal charges. The state can't force antipsychotics into someone just to put them on trial for a misdemeanor trespassing charge.
Okay, serious crimes only.
Second, the government must prove the forced medication will significantly further those state interests.
Meaning the drugs will actually work to restore competency.
Yes, and crucially, they must prove that the drugs will not cause severe side effects that would compromise the fairness of the trial.
Oh.
If the antipsychotics turn the defendant into a drooling zombie sitting at the defense table, the jury might subconsciously view them as remorseless or guilty. The medication cannot alter their demeanor so drastically that it ruins their right to a fair trial.
That is a very fine pharmacological needle to thread. What else?
The state must prove that forced medication is necessary to further those interests, and that any alternative, less intrusive treatments are unlikely to achieve substantially the same results.
Like therapy.
If intensive talk therapy might restore competency, the state has to try that before resorting to forced injections. Finally, the administration of the drugs must be medically appropriate. It must be in the patient's best medical interest in light of their specific condition.
So the state can force meds for serious crimes, but only if it's highly likely to work, won't ruin trial fairness, is the absolute last resort, and is medically sound. That is an intense mechanical framework.
Very intense.
Now, I want to pivot to a distinction that I know trips up a lot of students because the terminology gets used interchangeably in popular media: incompetency and insanity. In the legal architecture, these are not synonyms, are they?
They are completely distinct legal concepts. They operate on entirely different timelines with entirely different consequences. Confusing them on the MBE is fatal.
I try to visualize the distinction using the concept of time travel. When a defense attorney raises an insanity defense, they are asking the jury to look at a photograph of the past.
I like that.
They're asking, what was the state of the defendant's mind at the exact split second the crime was committed 3 years ago? Did they know right from wrong then?
That is a flawless mechanical visualization. Insanity is a retrospective analysis of criminal culpability at the moment of the act.
But when we talk about incompetency, under the standard we just discussed, we aren't time traveling. We're looking at a live video feed of the present moment. We are asking, what is the state of the mind right now, today, sitting at the defense table? Can they understand the trial process now?
Exactly. Insanity equals time of the crime. Incompetence equals time of the trial. And because the temporal focus is different, the structural outcomes are radically different.
Detail the outcomes for us. If my client successfully pleads insanity, what happens?
If the jury accepts an insanity defense, the defendant is found not guilty by reason of insanity. They are legally acquitted of the crime because they lacked the requisite mental state to be culpable.
But they don't just walk out of the courthouse.
No, they do not just walk out. They are typically committed to a secure mental health facility. And here is the kicker. They can be held there indefinitely until they are no longer a danger to themselves or others. Often, an insanity acquittee spends far more time locked in a hospital than they would have spent in prison for the underlying crime.
Wow. So insanity is an acquittal, but it can lead to lifelong institutionalization. Contrast that with the outcome of a finding of incompetency.
If a judge declares you incompetent to stand trial, there is no acquittal because there's no trial. The proceedings are just paused. And crucially, the state cannot hold an incompetent defendant in a mental hospital indefinitely solely based on their inability to stand trial.
Oh, really?
The confinement must be strictly limited to a reasonable period necessary to determine if there is a substantial probability that they will attain competency in the foreseeable future.
So if the doctors evaluate them and say this dementia is permanent, they will never be competent, the state has to let them go.
The state must either release them or institute standard civil commitment proceedings, the same proceedings they would use for any non-criminal citizen who is dangerously mentally ill. They cannot use the pending criminal charges as an excuse to lock them up forever without trial.
That is a fascinating systemic boundary. One last mechanical question on this topic. Burden of proof.
Okay.
If I am the defense attorney and I claim my client is incompetent, who has to prove it to the judge? Does the state have to prove he is competent, or do I have to prove he isn't?
The Supreme Court has ruled that a state is perfectly permitted to place the burden of proving incompetency squarely on the defendant. The state can presume competency and force the defense to rebut it.
That seems like a standard procedural hurdle.
It is, but the MBE trap lies in the quantum of proof required.
Explain the quantum.
A state may require the defendant to prove their incompetence by a preponderance of the evidence, meaning it is more likely than not a 51% threshold. However, the Supreme Court ruled that a state absolutely cannot require a defendant to prove incompetence by clear and convincing evidence.
Wait, why not? Why does the Constitution care about the semantic difference between preponderance and clear and convincing?
Because of the practical reality of mental illness. If a defendant is genuinely hovering right on the borderline of incompetency, their mind is fragmented. They are, by definition, struggling to assist their lawyer.
Oh, I see where this is going.
Right. To demand that a mentally fractured person gather enough cohesive evidence to meet a massive, highly demanding standard like clear and convincing creates an unacceptable risk that a truly incompetent person will be forced to stand trial. It violates due process to set the evidentiary bar that high.
The logic is unassailable. A broken mind cannot be expected to leap over an elite evidentiary hurdle to prove it is broken. Let's lock in our MBE recap for Section 3, Mind Matters.
The competency standard. Time of trial. Does the defendant comprehend the nature of the proceedings, and can they rationally consult with their lawyer?
The forced medication rule. The state can force antipsychotics for serious crimes only if the drugs won't ruin the fairness of the trial, are the necessary least intrusive means, and are medically appropriate.
The timeline distinction. Insanity looks backward to the time of the crime and results in an acquittal with potentially indefinite commitment. Incompetency looks at the present moment, pauses the trial, and strictly limits the period of commitment for evaluation.
And the burden of proof trap. States can force the defendant to prove their own incompetence by a preponderance of the evidence, but requiring them to prove it by clear and convincing evidence violates due process.
All set. We have successfully identified our suspect, we have legally justified holding them in a cell, and we have confirmed their mind is competent to face the machinery of the state. Now, the state must officially activate that machinery. They must bring formal charges.
And this brings us to Section 4. We are stepping out of the bright lights of the courtroom and walking into the most secretive, bizarre, and functionally archaic room in the entire justice system, the grand jury.
It is an institution that operates by its own set of rules, rules that completely contradict almost everything we normally associate with American judicial fair play.
Let's start with the foundational text. The Fifth Amendment explicitly states that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Based on a plain reading, that sounds like a mandatory constitutional requirement for every felony in America.
And that is your first major constitutional law crossover trap. That Fifth Amendment mandate applies strictly to the federal judicial system. It is absolutely mandatory for federal felonies.
But not for states.
Exactly. The grand jury clause of the Fifth Amendment is one of the very few provisions of the Bill of Rights that has never been incorporated by the 14th Amendment to apply to the individual states.
I want to break down what not incorporated means mechanically for the listener. Because if a right isn't incorporated, it basically doesn't exist at the state level, right?
Correct. It means the United States Constitution leaves the decision entirely up to the individual states. They are not federally required to use grand juries at all, while many states, particularly on the East Coast, still utilize them to issue a true bill of indictment. A huge number of states, especially in the West, have abandoned them entirely for routine felonies.
If a Western state doesn't use a grand jury, how do they formally charge someone?
The prosecutor simply drafts and files a document called an information. It's just a formal accusation signed by the prosecutor, usually followed by the adversarial preliminary hearing we discussed earlier to verify probable cause.
So if an MBE question presents a state court bypassing a grand jury and sending a defendant straight to trial based on a prosecutor's information, there is zero constitutional violation.
Exactly. But let's assume we are in federal court, or a state that mandates them. We need to step inside the grand jury room and look at the mechanics, because the vibe is completely alien to standard procedure.
The analogy I use is that the grand jury is an exclusive, highly secretive club, and the prosecutor is acting as the bouncer, the DJ, and the bartender, all rolled into one.
I love that.
The defendant is emphatically not invited to the club. They do not get to be in the room, and they certainly don't get to bring their defense attorney to argue on their behalf.
That is a highly accurate visualization. The grand jury is entirely non-adversarial and operates in strict secrecy. The defendant has absolutely no constitutional right to appear before the grand jury. Even if the prosecutor decides to subpoena the defendant and force them to testify as a witness, the defendant still has no right to have their attorney inside the grand jury room with them.
Wait, if I am forced to testify under oath in front of 20 grand jurors, my lawyer just has to sit out in the hallway?
Yes. You can ask for permission to step outside the room to consult with your lawyer after every single question, but the lawyer cannot cross the threshold into the room.
That is crazy.
Furthermore, the defense has no right to present their own witnesses, no right to confront or cross-examine the state's witnesses, and no right to introduce evidence.
That sounds incredibly one-sided. But surely the prosecutor has an ethical obligation to play fair, right? If the prosecutor has a surveillance video clearly showing the defendant was in another state at the time of the murder, they have to show that to the grand jury to stop an innocent person from being indicted.
Shockingly, no. The Supreme Court ruled that a prosecutor has absolutely no constitutional obligation to present exculpatory evidence to a grand jury.
Wait, really?
The prosecutor's job in that room is solely to advise the jury on the law and present the state's affirmative case for probable cause. If they have a video proving you are innocent, they can keep it hidden in their briefcase, get the indictment, and force you to trial. You cannot get an indictment dismissed later simply by proving the prosecutor hid exculpatory evidence from the grand jury.
That is functionally terrifying. It is truly a prosecutor's playground. What about the rules of evidence? In a normal trial, there are massive, complex rules excluding hearsay or blocking evidence that the police obtained through an illegal warrantless search. Do those rules apply in this secret club?
Not at all. The grand jury operates as an anything-goes environment. The Supreme Court has been unequivocal that a grand jury is not restricted to hearing evidence that would be legally admissible at trial.
Give me a mechanical hypothetical for this because it feels counterintuitive.
Let's start with illegally obtained evidence. An indictment can be based entirely on evidence seized in blatant violation of the Fourth Amendment. Imagine the police kick down your front door without a warrant, tear your house apart, and find a kilogram of cocaine.
Okay.
Because the search was illegal, the exclusionary rule guarantees that the prosecutor can never show that cocaine to a trial jury. But the prosecutor can walk into the grand jury room, plop that exact same illegally seized cocaine on the table, and use it to get an indictment against you.
The mind boggles. What about hearsay?
Allowed. A grand jury indictment can be based purely on hearsay evidence. The prosecutor doesn't need to bring in the actual witnesses to the bank robbery. They can just bring in the lead detective, sit him in the chair, and have him say, "I talked to 5 people on the street, and they all said the defendant did it." That secondhand hearsay is sufficient to secure a valid indictment.
Why does the Supreme Court allow this? Why strip away all the evidentiary protections that define American justice?
Efficiency. The court's rationale is that the grand jury is merely an investigatory screen. Its only job is to determine if there is probable cause to justify the burden of a trial. It is not deciding ultimate guilt or innocence. If we forced the grand jury to hold adversarial mini-trials on the admissibility of every single piece of evidence before they could even issue an indictment, the entire criminal justice system would grind to a permanent halt.
Is there literally any limit? Is there any piece of evidence a grand jury is forbidden from hearing?
There is one major exception you need to memorize, and it is based on a federal statute, not the Constitution.
What is it?
Information obtained from an illegal wiretap cannot be presented to a grand jury.
Okay, so the police illegally searching your physical house is fine for the grand jury, but illegally tapping your phone is strictly off limits. That is a highly specific MBE distinction. Let's look at another constitutional protection. Double jeopardy. The rule that you can't be tried twice for the same crime. Let's say the prosecutor brings their hearsay and their illegal evidence, and the grand jury still looks at it and says, "Nope, we don't buy it. No true bill." Is the defendant safe?
Not even slightly. The double jeopardy clause does not apply to grand jury proceedings because jeopardy does not attach at the indictment phase.
When does it attach?
Jeopardy only attaches when a trial actually begins, meaning when the trial jury is sworn in or when the first witness is sworn in for a bench trial. Therefore, if grand jury number 1 refuses to indict you, the prosecutor can simply walk down the hallway the next day, convene grand jury number 2, and try again with the exact same evidence.
It just keeps getting worse for the defense.
Yeah.
What if I'm the one called into the room to testify? If I sit down in that chair, do the prosecutors at least have to read me my Miranda rights? You have the right to remain silent.
No. Miranda warnings are not required in a grand jury room. And here is a deeply deceptive trap. Let's say you are the actual target of the investigation. The prosecutor secretly plans to indict you, but they subpoena you to testify first, hoping you'll say something incriminating. They do not have to warn you that you are a putative defendant.
So I walk into the room thinking I'm just a helpful witness, completely unaware that the prosecutor is actively building a trap to indict me.
Exactly. And if you sit in that chair and lie to the grand jury, you can be convicted of perjury, and you cannot defend yourself against that perjury charge by arguing, well, the prosecutor didn't read me my Miranda rights and they didn't warn me I was a target. The Supreme Court made it clear, lying under oath to a grand jury is punishable, regardless of procedural warnings.
Okay, let's step out of this terrifying room for a moment. Let's assume the grand jury issues the indictment. As a defense attorney, are there any viable grounds to challenge the structural integrity of the grand jury itself? If it's a secret, anything-goes environment, how do you ever win a motion to dismiss?
It is exceptionally difficult. A defendant is not entitled to a dismissal of an indictment due to a procedural defect unless they can meet a massive burden, proving that the defect substantially impacted the grand jury's decision to indict. However, there is one absolute non-negotiable deal breaker that shatters the whole process.
The ultimate constitutional line in the sand.
Yes, intentional racial discrimination in the selection of the grand jurors.
Break down the mechanics of this.
If the defense can prove that individuals were intentionally excluded from serving on the grand jury panel based on their race, it violates the Equal Protection Clause.
And what is the mechanical remedy if you prove this?
It triggers an automatic reversal of the subsequent criminal conviction.
Let me push back on that because I know how appellate courts work. Let's say the grand jury selection was racially discriminatory. The indictment drops. The defendant goes to a full, fair public trial. A perfectly selected, diverse trial jury hears overwhelming evidence of guilt, DNA, video, 10 eyewitnesses, and convicts the defendant. On appeal, can't the state just use the harmless error defense? Can't they say, yes, the grand jury was racist, but the trial jury was fair and the evidence was so overwhelming that the defendant would have been convicted anyway, so the error was harmless?
The Supreme Court explicitly rejected that exact argument. The state cannot use the harmless error defense here. The court ruled that intentional racial discrimination in the creation of the grand jury is a structural error. It so fundamentally poisons the well of justice and so deeply undermines the structural integrity of the entire judicial system that the subsequent conviction must be overturned, regardless of how overwhelming the evidence of guilt was at trial.
Does the defendant have to be a member of the specific race that was excluded to raise this challenge? For instance, if I am a white defendant and my lawyer discovers that the state intentionally, systematically excluded black citizens from the grand jury pool, can I get my conviction overturned?
Yes, you can. The Supreme Court held that a defendant does not need to be a member of the excluded race to have standing to challenge the discriminatory selection. The constitutional harm is not just to the defendant. It is an assault on the integrity of the system itself, and any defendant can raise it.
That is a powerful systemic check. Let's lock in our MBE recap for Section 4, the grand jury.
First, the Fifth Amendment right to a grand jury is not incorporated to the states. States can use an information instead.
Second, it is a secretive, non-adversarial process. The defendant has no right to be there, no right to counsel inside the room, and no right to present evidence. Furthermore, the prosecutor has zero obligation to present exculpatory evidence.
Third, the rules of evidence do not apply. Indictments can be based on hearsay or illegally obtained evidence. The singular exception is information from an illegal wiretap.
Fourth, double jeopardy does not attach to the grand jury stage, and witnesses are not entitled to Miranda warnings or target warnings. If you lie under oath, you will be convicted of perjury.
And fifth, the structural deal breaker. Intentional racial discrimination in selecting grand jurors mandates an automatic reversal of the conviction. The harmless error defense is forbidden, and any defendant, regardless of their own race, has standing to challenge it.
We are surviving the gauntlet. We have reached our final chronological stage, Section 5. The grand jury indictment has been secured. The secret, one-sided investigatory phase is officially over. We are now heading toward the public battlefield of the trial, and mechanically the rules of the game change entirely for the prosecutor.
Drastically. Inside the grand jury room, the prosecutor could hide whatever they wanted. But once that indictment drops and the adversarial trial machinery engages, the Due Process Clause demands that the state open its files to ensure a fair fight.
This brings us to one of the most famous, most heavily litigated rules in all of criminal law: the duty to disclose favorable evidence. Explain the mechanism of this rule.
This rule mandates that the prosecution has an affirmative constitutional duty to disclose to the defense any material evidence that is favorable to the defendant.
Let's parse the word affirmative. Does that mean the defense attorney has to file a specific, detailed motion asking for the evidence?
No. Affirmative duty means the obligation rests entirely on the government's shoulders. Even if the defense attorney is incompetent and asks for absolutely nothing, the prosecutor must proactively search their files and hand over the favorable evidence.
And what legally constitutes favorable evidence?
Favorable evidence generally falls into two distinct categories: exculpatory evidence and impeachment evidence.
Exculpatory is the obvious one, right? Evidence that directly points to innocence.
Yes. Exculpatory evidence tends to negate the guilt of the defendant or diminish their culpability. For example, the police recover a bloody knife at the murder scene. They test the DNA on the handle, and it comes back as a 100% match to a known, convicted serial killer who is not the defendant.
That DNA report is massively exculpatory.
Exactly. The state must hand it over.
But impeachment evidence is more subtle. It doesn't necessarily prove I didn't do it.
Correct. Impeachment evidence attacks the credibility or reliability of the state's own witnesses or evidence. It's the material the defense uses on cross-examination to destroy the prosecutor's case. The Supreme Court confirmed that the duty to disclose applies equally to impeachment evidence.
Give me a mechanical hypothetical for impeachment evidence.
Let's say the prosecutor's entire case rests on the testimony of a jailhouse informant who claims you confessed to him in your cell. What the jury doesn't know is that the prosecutor secretly signed a deal with this informant, promising to drop his armed robbery charges in exchange for his testimony against you.
A secret deal.
That secret deal doesn't prove you're innocent, but it proves the informant has a massive financial and liberty incentive to lie on the stand. That is textbook impeachment evidence, and the prosecutor must disclose the deal to your lawyer.
Okay, I want to push back on the reality of how this works in a massive bureaucracy. We know prosecutors handle hundreds of files simultaneously. What if a prosecutor genuinely makes an honest mistake?
Okay, lay it out.
Let's say the lead detective on a case receives a lab report showing a witness was legally blind. The detective accidentally misfiles it in a different cabinet. The prosecutor literally never sees it. They go to trial completely unaware the report exists. They didn't mean to hide it. Does a good faith bureaucratic error still trigger a constitutional violation?
The intent of the prosecutor is entirely irrelevant. This disclosure rule is functionally a strict liability standard for the state. The focus of the Due Process Clause is on the fairness of the trial for the defendant, not on punishing the moral culpability of the prosecutor.
Wait, if the detective hides it, the prosecutor is still on the hook.
Absolutely. The court ruled that the prosecutor has an affirmative duty to learn of any favorable evidence known to others acting on the government's behalf in the case, including the police. You cannot silo the police department off from the district attorney's office and claim ignorance. The state is viewed as one monolithic entity. If the state possesses it and it's favorable, hiding it accidentally or maliciously is a violation.
So if evidence was suppressed, regardless of intent, is the resulting conviction automatically thrown out?
No, it is not automatic. Just because evidence was suppressed doesn't mean you win the appeal. The defense must prove the specific elements of a violation. You must show three things. First, the evidence was favorable to the accused. Second, the evidence was suppressed by the state, either willfully or inadvertently. And third, the suppression resulted in prejudice to the defendant.
Prejudice. Let's unpack the mechanics of that word in this context, because I imagine courts define it very specifically.
They do. Prejudice means that the suppressed evidence was material. And evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different.
Let me test the boundary of materiality with a hypothetical. The prosecutor suppresses a police report where a bystander notes the getaway car was a dark navy blue. At trial, the main witness testifies the car was black. The defense discovers the suppressed report after conviction. Is that a violation?
Almost certainly not. It is technically favorable. It could slightly impeach the witness's memory of the color, and it was suppressed. But where is the prejudice? If the state also presented high-definition security footage of the defendant driving the car and the defendant's fingerprints were on the steering wheel, a minor discrepancy about navy blue versus black would not have created a reasonable probability of a different outcome. The error is harmless.
But if they suppressed the secret deal with the jailhouse informant, and that informant was the only piece of evidence the state had linking the defendant to the crime,
then the prejudice is massive. Destroying the informant's credibility would completely destroy the state's entire case. That creates a high probability of a different outcome. The evidence is deemed material, and the conviction is overturned.
Okay, so favorable evidence, suppressed by the state, causing a reasonable probability of a different outcome. Are there any systemic exceptions to this duty? Are there times on the timeline when the prosecutor can legally hold on to favorable evidence?
Yes, the source material highlights two critical timeline limitations on the disclosure mandate. The first involves the plea bargaining phase. The Supreme Court held that the prosecution does not have a constitutional duty to disclose impeachment evidence prior to entering into a plea agreement with the defendant.
Let me make sure I understand the mechanics of this. The prosecutor can approach me, offer me a plea deal of 5 years instead of 20, and legally conceal the fact that their star witness is a convicted perjurer.
Yes, they can. The court's rationale here is heavily rooted in systemic efficiency. Impeachment evidence is inherently tied to the fairness of a trial. It is used to cross-examine witnesses on the stand. If you are voluntarily choosing to plead guilty and waive your right to a trial entirely, the state isn't required to prematurely open its files on witness credibility just to help you negotiate a better bargain.
That seems harsh.
Requiring full disclosure before every plea deal would essentially force prosecutors to prep for trial on every single case, destroying the efficiency of the plea system.
It feels like a harsh reality of a system built on assembly line justice, but the institutional logic tracks. What is the second timeline limitation?
The post-conviction phase. The Supreme Court ruled that the duty to disclose does not extend indefinitely into post-conviction proceedings.
Why not? If the state finds proof of my innocence 10 years after I am locked in a cell, shouldn't they be forced to hand it over?
The state may have ethical obligations, but the strict constitutional mandate diminishes significantly once a conviction becomes final after direct appeals. The court reasoned that a convicted defendant no longer enjoys the presumption of innocence. At the post-conviction stage, the state's profound interest in the finality of judgments begins to outweigh the pre-trial demand for open discovery. The trial was the main event. Once it's over, the constitutional spigot largely turns off.
Finality over absolute truth. A chilling but mechanically necessary reality of the system. Let's lock in our final MBE recap for Section 5, Playing Fair.
The disclosure rule. The prosecution has an affirmative constitutional duty to disclose material evidence favorable to the defense, encompassing both exculpatory and impeachment evidence.
The standard. The prosecutor's intent is irrelevant. Inadvertent suppression is still a violation. The defense must prove the suppressed evidence was material, meaning there's a reasonable probability it would have changed the outcome of the trial.
The exceptions. There is no constitutional duty to disclose impeachment evidence prior to a plea bargain, and the strict disclosure duty does not extend into post-conviction proceedings.
We have made it. We have traced the complete chronological timeline of the pretrial system. For you, the listener, grinding through your bar prep, navigating this gauntlet is an immense achievement. Let's do one final rapid-fire structural review of the journey.
We started out in the physical world in the lineup lab. We saw how the Sixth Amendment blast shield only deploys post-indictment, while the Due Process Clause universally protects against police-arranged suggestiveness unless justified by extreme emergency.
Then the handcuffs clicked and the ticking clock began. We examined the 48-hour limit for the non-adversarial probable cause check, contrasted it with the adversarial lawyer-mandated preliminary hearing, and dispelled the myth of a constitutional right to bail, replacing it with the Eighth Amendment protection against excessive numbers.
We paused the physical timeline to interrogate the mental state of the defendant. We distinguished the present tense requirement of trial competency and the severe hurdles for forced medication from the retrospective time travel defense of insanity. We noted that forcing a defendant to prove their own incompetence by clear and convincing evidence is a bridge too far for due process.
We then stepped into the deeply unsettling, secretive world of the grand jury, where prosecutors act unchecked, utilizing hearsay and illegally obtained evidence. But we noted the ultimate structural tripwire. Intentional racial discrimination in jury selection triggers automatic reversal.
And finally, we saw the pendulum swing back toward fairness as trial approached, with the disclosure rule forcing the state to open its files and hand over favorable evidence, regardless of the prosecutor's good or bad faith, provided it affects the likely outcome of the case.
It is a massive amount of material, but I want to leave you with a completely different paradigm to ponder as you review your outlines. We have spent this entire deep dive analyzing a system built around human flaws.
The entire architecture is designed to manage human error. We create reliability factors to measure the decay of human memory. We build disclosure rules because human prosecutors succumb to tunnel vision. The rules exist because humans are subjective, biased, and fallible.
Exactly. But look at the horizon of the legal profession. What happens to this entire intricate pretrial gauntlet when artificial intelligence fully enters the chat?
That is a profound structural question.
Think about the lineup lab. What happens when we replace the flawed human eyewitness looking through a two-way mirror with an algorithmic facial recognition sweep of city cameras? Does the due process argument of impermissibly suggestive even apply to code? Think about bail. We already see jurisdictions using algorithmic risk assessments to decide who gets out and who stays in the cell. If an AI decides you're a flight risk, how does your lawyer cross-examine a proprietary algorithm at a probable cause hearing?
It threatens to upend the balance entirely. The rules we discussed today, the right to counsel, the ban on excessive bail, the evidence disclosures were drafted to check the power of human institutional actors. If we outsource the mechanics of probable cause and identification to black box algorithms, we might eliminate human bias, but we risk encoding systemic bias into a machine that the Constitution doesn't currently know how to regulate.
Does the system finally achieve the clean, binary precision of the X-ray machine we talked about at the beginning, or do the diagnostic waters just become mathematically impenetrable? It's a fascinating layer to consider as you master the current rules, because the law you are studying right now is just the foundation for the battles you will be fighting in the courtroom tomorrow.
Master the foundation first. Understand the why and the how behind the human mechanics, and the MBE questions will begin to look like simple equations.
To you, the listener, we are signing off. Keep reviewing those recaps. Trust the structural logic behind the case law. You have navigated the murky waters, and you are more than ready for whatever this exam throws at you. Best of luck.